They asked for 2 crores maintenance.
2 crores monthly maintenance,
And then
500 crores compensation.
For a person who is worth 20,000 crores, they're extremely powerful in Dubai.
what a wealthy man he is. He is going to give me so much of money.
Alimony.
Plus maintenance. The whole object of this is to extract money. It is submitted that after the said confrontation with the respondent, petitioner has been ill-treated by arrogance and sadist character of the respondent, but petitioner has tolerated all cruelty meted out by respondent for the sake of maintaining cordial family relationship with the fond hope that the respondent will correct himself, but by taking advantage of the same, respondent has tortured, harassed, and humiliated in all aspects since 2019. Then they come to the aspect of how rich the respondent is. The whole object of this is to extract money, because the rest of it, my lord, is what a wealthy man he is. Now he is going to give me so much of money.
Alimony.
That's the prayer, my lord. Plus maintenance. Yes, 2 crores, no?
Alla, compensation.
Illa. They asked for 2 crores maintenance.
2 crores monthly maintenance,
And then my lord,
500 crores
100
compensation.
crores, my lord, compensation under section 22.
We'll hear the respondent.
Yes. And there are a few authorities that I want to place.
Apart from what they...
My lord,
what
one, my lord, I want to point out your lordships, my lord, on section 4. Kindly see, my lord, section 4 of the IPC as it then was. In where the law wanted to provide for extraterritorial operation, it specifically said so. Kindly see section 4.
You told me in the beginning.
Yeah, section 4 no,
Yes.
of the IPC. ಇದು ಆಮೇಲೆ ನೀವು
ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವು ಫಸ್ಟ್ ಡೇ ಮಾಡಿದಾಗ
ಮಾಡಿದೆ ಹೌದು ಇಲ್ಲ ನೋ my lord, I'm substantiating with reference to the law.
extension of the court to-
Yes, to extraterritorial offences, where the lawmakers intended that the law here should apply to acts which are committed outside the country, they specifically said so.
There's no
Such a-
IPC offense here.
yes, such a provision is absent in DV Act, is what I'm pointing out. My lord, that is the contrast, my lord, that I want to point out, your lordships. In IPC, if I commit an offense outside, it's an offense under the IPC, a person can be tried here. But it is not so with respect to DV Act. Domestic violence committed outside does not attract the provisions of the DV Act within. That's the submission I'm making. Then, my lord, there are a few citations that I want to place for your lordship's consideration. Yes, my lord. My lord, please see, my lord, there is one judgment that I want to point out to your lordships, my lord, in 1963 Supreme Court, page 1. That is the famous Vishwanathan case, my lord. It is found, my lord, in which citation?
This you took me through bird of passage.
No.
Huh?
Bird of passage. No, my lord. Vishwanathan's case is on how section 13 of the CPC has to be construed and how it is to be done. Not for the purpose of
That-
birds of passage. I have already
No,
shown.
orders passed by foreign court.
Foreign courts. And your lordships will not look at the order passed by a foreign court with reference to the law in India.
Obviously, yes.
Your lordships will look at the enforceability of a foreign judgment with respect to the law in that country.
Yes.
That is what my lord Vishwanathan case lays down. It is a very famous case, my lord, right from
And the concept is rudimentary.
my lord.
Concept is rudimentary.
But it has received the attention of
Yes.
such.
Yes, sir.
It's a judgment, my lord, which your lordship may just see these paragraphs, my lord.
19 and 20.
Yes, no, my lord. 2021.
All right.
If I may just read that, my lord.
Yes, sir.
Undoubtedly, in fact, this is a case where, my lord, Mysore state was a foreign state compared to Bombay. In that context, the enforceability of a judgment of the Mysore court was called in question. Undoubtedly, my lord, para 19, my lord. Undoubtedly, a court of a foreign country has jurisdiction to deliver a judgment in rem, which may be enforced or recognized in an Indian court, provided the subject matter of the action is property, whether movable or immovable, within the foreign country. It is also well settled that the court of a foreign country has no jurisdiction to deliver a judgment capable of enforcement or recognition in another country in any proceeding, the subject matter of which is titled to immovable property outside the country. But there is no general rule of private international law that the court can in no event exercise jurisdiction in relation to persons, matters, and property outside jurisdiction. Express enactment of provisions like Section 20 CPC and Order 11 of the Supreme Court rules in England negative such assumption. The courts of a country generally impose a threefold restriction upon the exercise of their jurisdiction. Jurisdiction in rem by a court over res outside the jurisdiction will not be exercised because it will not be recognized by other courts. The courts will not deal directly or indirectly with title removable property outside the jurisdiction of the state from which it derives its authority. And three, court will not assist in the enforcement within its jurisdiction of foreign penal or revenue laws. The suit filed by the plaintiff was possession of estates disposed of by the will of Ramalingam in para 3 of the plaint in Bangalore District Court suit. Then that's on the facts. I'm not going
That's
to
on the facts, not, that's
I'm
why,
not going. I'm not going.
that's why I said 1920.
Yes, madam. Kindly now see para 24. In an action in personam,
Hmm.
the court has jurisdiction to make an order for delivery of movables where the party is submitted to the jurisdiction. This is
Yes.
important.
Yes.
A person who institutes a suit in a foreign court and claims a decree in personam cannot, after the judgment is pronounced against him, say that the court had no jurisdiction which he invoked and with the court exercised, for it is well recognized that the party who is present within or who has submitted it to jurisdiction cannot afterwards question it. This is the point. Well, this is the case where both of them have gone and done it. And the order of divorce granted, my lord, records that it is a joint application. So, my lord, having regard to the law laid down in para 24 of this judgment, they cannot question it,
All right.
having
We'll-
submitted themselves.
We'll hear the counsel,
Very well, madam. If there's anything in reply, I'll point.
anything.
Very-
Because both of you have extensively heard when the matter was taken up on the first time. The first occasion.
And after my learned friend, if my learned friend is going to rely upon any of the subsequent pleadings which has been filed in this case, post the petition that was filed before the DV court, I will point out, my lord, how they have purged themselves.
All right.
Might
Yes,
I
madam.
request your lordship the Domestic Violence Act?
Ah.
3 verbal and emotional abuse includes
Hmm.
insults, ridicule, humiliation, name calling, insults, ridicule, especially with regard to not having child, male child, whatever.
Hmm.
Next, repeated threats cause
Mm.
physical harm. Next is economic abuse, which is also something we've raised. Deprivation of all or any economic or financial resources to which the aggrieved person is entitled to under law.
Mm.
The other one is last C, prohibition or restriction to continued access to resources or facilities which the aggrieved person is entitled to use, enjoy by virtue of domestic relationship, including shared household.
Mm.
Now, they try to say that she's staying in a hotel, and probably birds of, I'd rather say paradise. So instead of passage.
Yes.
Lordship, if she's not allowed into her home, and they might find it amusing that we are trying to say that she's under constant threat. But a person who is worth 20,000 crores, as I mentioned to your lordships, that even the zeros that we cannot count, they're extremely powerful in Dubai. Even after her giving her initial complaint, and which proof of which by way of a WhatsApp message, of a message that she received on her phone, which is produced before your lordship, she was told very clearly after that, since there are several cases pending in Bangalore in India, why don't you address it there? After that, they will unwilling to take it up. Your lordship, in fact, I have noticed that even the metro stations there are named after top Indian builders. They have sufficient and tremendous power over there. With respect to her in her, the Dubai consulate, there are several occasions when they have gone to the Dubai consulate with respect to issues on passport, several issues, they have gone there. She has also gone there. Now she's unaware of this. Now what they're trying to take is bring out a certain message between the two there where she says, yes, I might not be your wife. Reason being he has told her that there's a provision and I have used that and I've gone and got myself a divorce is what he says. So I'm led to believe that there is one. But later, which I have taken your lordship through those messages, it says, give me a divorce, come to India and sign it, and then I will give you the Dubai house. That is when she realizes that that was a fabricated document or a lie or whatever she was led to believe. And now he's pushing her to give her the divorce in Dubai.
2 करोड़ हर महीने और 500 करोड़ का मुआवजा। सुनने में फिल्मी लगता है, लेकिन ये मांग सच में पहुंची कर्नाटका हाई कोर्ट में। इस मामले की सुनवाई कर रहे थे जस्टिस एम नागाप्रसन्ना और मामला था एक मैट्रिमोनियल डिस्प्यूट का। पत्नी की तरफ से कहा गया कि उन्हें 2 करोड़ प्रति माह मेंटेनेंस चाहिए, साथ ही 500 करोड़ का कॉम्पनसेशन भी मांगा गया। अब सोचिए, इतनी बड़ी रकम, लेकिन क्या कोर्ट ने इसे मान लिया? जवाब है नहीं। कोर्ट ने साफ तौर पर कहा कि मेंटेनेंस कोई डिमांड बेस्ड सिस्टम नहीं है जहां जो चाहे वो रकम मांग ली जाए, बल्कि मेंटेनेंस तय होता है पति की इनकम पर, दोनों की लाइफस्टाइल पर और केस के एक्चुअल फैक्ट्स पर। कोर्ट ने यह भी संकेत दिया कि ऐसे अनरियलिस्टिक क्लेम्स को ब्लाइंडली एक्सेप्ट नहीं किया जा सकता और आखिर में जो राहत दी गई वो इन भारी भरकम डिमांड से काफी कम और रीजनेबल थी। इस केस से क्या सीख मिलती है कि कोर्ट में सिर्फ बड़ी बड़ी मांगे करने से कुछ हासिल नहीं होता। कानून हमेशा बैलेंस और फेयरनेस को देखता है। इसलिए जब भी आप ऐसे वायरल हेडलाइंस देखें, 500 करोड़ की मांग, 2 करोड़ महीना, तो पूरी सच्चाई जरूर समझिए, क्योंकि असली फैसला अक्सर कुछ और ही होता है। ऐसे ही शॉकिंग लेकिन रियल कोर्ट केसेस जानने के लिए अभी सब्सक्राइब करें, क्योंकि सच हमेशा हेडलाइन से बड़ा होता है। धन्यवाद।